today. Great to see you here. So first of all, I'd just like to say, please do, as we're going along, feel free to shout out and interrupt, ask questions. You can wait till the end if you wish. The choice is yours, but I really don't mind if people want to, sorry, just bear with me, also try and share my screen. Feel free whilst we're on a particular topic to ask questions then, or wait until the end. So, cracking on with it. In terms of what I'd like to cover today, would be, first of all, a look at the potential change in legislation. I know everybody's quite excited about this potential change. It's going to make life easier for fundraisers. So we'll talk about that first, and then a quick overview of the law, how that applies to us, and where the boundaries are, and then in practice, how does the law apply to us on a day-to-day basis in terms of both marketing and fundraising, because they are two different, although similar things, they are two different things in the eyes of the law. And we'll look at both electronic marketing and fundraising and postal, again, because the rules are very, very different. And then that probably, I think, one of the very difficult questions is the difference between a service-based communication and marketing, because it can be a very grey area sometimes, and look at what the ICO's view on this is and their opinion, which is a little bit grey as well, unfortunately. And then very specific rules that only apply to fundraising communications. And then finally, at the very end, we'll have a quick look at, if it all goes horribly wrong and the Information Commissioner gets involved, how they're likely to react, although that's always a difficult one to gauge sometimes. But before we do any of that, I thought what might just be helpful for some of us, because I'm not quite sure what everybody's knowledge base on this is. I see there's some very experienced data protection people in the meeting today, but a quick rundown on some definitions, just so that as I'm talking, you know what I'm talking about. So when I talk about the data subject is a living individual who the information is about. So potentially that's going to be the supporter, or it could be a member of staff who's an employee, but essentially it's somebody who the data is about. Then data controller, that's the hospice, that's the organization responsible for the information and seeing how it's going to be used. It's also the organization that will get busted if things go horribly wrong. And then probably the most important thing to get your head around, because this is where the big differences are, we've got what are called corporate subscribers and private subscribers. Now, in addition to the Data Protection Act and the GDPR, we've got another piece of legislation that's very, very important when it comes to marketing and fundraising, called the Privacy and Electronic Communications Regulation, a nice snappy name, also known as PECA. And it talks about corporate subscribers and private subscribers. And what it essentially means is a corporate subscriber is where the email account, so david@dataprotectionconsultancy.com, or the telephone number, so my work telephone number, who owns those numbers. And if that email address, landline number, even mobile phone number is owned by a corporate body, so that can either be a limited company, a PLC, a registered charity, then that's seen as a corporate subscriber. And the rules on marketing and fundraising to corporate subscribers are softer than those when you come to contacting a private subscriber. And a private subscriber is essentially where that email address or phone number is owned by a private individual. So even if it's a free email account, like a Hotmail account, where you kind of nobody really owns it other than possibly Microsoft, even free email accounts, that's a private subscriber. And it becomes a little bit tricky with, first of all, sole traders, because a sole trader might have their own email address, David at, dataprotectionhelp.com. And I don't operate through a limited company. I just operate as a sole trader. And by looking at that email address, you wouldn't know one way or the other whether whether that was a private subscriber address or not. So the ICO specifically say you need to be quite careful when marketing to what you think are corporate email addresses and also phone numbers. They really are corporate subscribers and not private subscribers. The greater challenge comes with mobile phones, because you have no idea when somebody provides you with their mobile phone number, whether it's their personal mobile phone or their work mobile phone. A lot of us now, aren't given work mobile phones anymore, but we use our personal mobile phone for work. I know my mobile phone is my own, but I have the number on my email footer. So need to be careful. The other thing just worth bearing in mind with private subscribers, limited liability partnerships, which is usually limited to law firms and some accountancy practices, they're also viewed as private subscribers and not as corporate subscribers. But I will say that the Information Commissioner has never ever taken enforcement action against anybody for marketing, let's call it unsolicited marketing, to an LLP. The definition of marketing, or the ICO's definition of marketing, is anything that promotes a product, service, aim, or ideal. Of course, that includes fundraising as well. So it's a very, very broad definition. And in terms of, I think, the work you guys are doing, is fundraising falls into that aim or ideal bit of the definition. And the ICO's definition of fundraising specifically is any communication that promotes a charitable event or directly asks for charitable support. So if you, for example, took a newsletter would, as long as it had no fundraising promotional content, so it was just talking about, we've just built a new wing on the hospice, we've just got a great review from the Care Quality Commission, and you're just talking about, the day-to-day great business that's, and things that are going on in the charity, and we're not promoting any fundraising events, we're not asking people to put their hand in their pocket, that would be seen as marketing. But if in that newsletter you added something in where you started promoting a charitable event, for example, let's say it's your annual fun run or something like that, something that's coming up and you promote that, it turns the newsletter into fundraising. Consent, which I'll talk about in more detail, is defined as any positive action taken to agree to something specific. So, it doesn't have to be a tick in a box, it can be verbal, but we're telling somebody, we want to do this with your information, and we're specific about what that thing is, and they go, yeah, I'm good with that. And that's the definition of consent. And it has to be freely given, so we can't sort of twist people's arm into consent. It really has to be freely given, fully informed, and most importantly, they can withdraw that consent at any time, which is why you put unsubscribes on marketing and fundraising communications, and why in your privacy notice, hopefully it will say something like, if you ever want to unsubscribe from any of our mailing lists, just get in touch through this address or give us a ring. Finally, service-based communications. This is any communication that is a factual operational nature. So there's no promotional content in it whatsoever. It's something like, so for example, if you are having let's go back to your annual fun run. So you've got all your participants involved in that, and the day before you wanted to maybe the week before, you want to send a reminder out to them with just to remind them what the arrangements for the day are going to be. You need to turn up by 10 o'clock, make sure you've brought your badge with you, make sure you've got this, make sure you are going to need all of these things. That would be a service-based communication. It's got no promotional content, and it's there specifically to guide people on a particular topic. So moving on, which is more than the slides are doing. In terms of which laws apply, well, I've already mentioned PECA, the Privacy and Electronic Communications Regulation. The ICO have an absolutely fantastic guide to marketing and fundraising. If you've not read it already, it's quite a hefty read. I think it's about 80 odd pages. It's really worth downloading a copy off their website and having a read. It's probably one of the best publications the ICO has ever written. I will say though, they regularly tweak it, and they don't always change the version number when they tweak it. So it is worth reading it at least once a year, downloading a fresh version and reading it once a year. Then, of course, we have the UK GDPR and the Data Protection Act. And then I think something people often forget is the telephone preference service, and not just the domestic telephone preference service. There's also a business telephone preference service, which applies in the same way the domestic telephone preference service applies. It used not to. The business, if we were having this conversation 5 years ago, the business telephone preference service was only optional. So in terms of if we're promoting to major donors and maybe ringing people in the workplace and what have you, and looking for, fundraising and support from corporations, and we're cold calling, then you'd need to consider the business telephone preference service. But I'll talk more about telephone preference service in a bit. Mail preference service, as I'm sure you're all aware, and the fundraising preference service. Now, the fundraising preference service is not statutory, so you don't have to comply with it. I appreciate if you're a member of the fundraising regulators group, then they say if you're going to be a member, then you have to comply with the fundraising, with our preference service. But that's just the conditions of terms of being a member. In law, you don't have to comply with it. Although I would say, I think you should, because if you get a complaint to the Information Commissioner, to be able to evidence that you're working to the highest standard, and we're even complying with unsubscribe and suppression lists that aren't compulsory, it puts you in a good position. And my experience of dealing with the ICO over the last 20 years is that they're not out there to prosecute you and make your life miserable. They're genuinely there to support and help you, and they understand that sometimes organizations get it wrong, and if you can show to the ICO that you were trying your best, you can show them your workings out, I suppose this is a good way of putting it, that we did this, we did it, we checked it against the fundraising preference service and the mail preference service, and we did a privacy impact assessment maybe as well. And we were trying our best. We were trying to be fair with people. They'll grumble at you and you'll get shouted at a little bit, but it will go no further than that. The reason the ICO prosecute organizations is simply because they're not listening, they're not trying, and they're not treating people fairly. And that's the real takeaway from this, is be as fair as you can with people, with your supporters, and if it goes wrong, the ICO will be supportive of you. The ICO also understand that there's a lot of people out there who use the ICO to basically beat up data controllers and will complain for the smallest thing. And I see an increasing number of people complaining to the ICO, and the ICO either not even bothering to contact the data controller, or just sending a courtesy, we've had a bit of a grumble from somebody about this, we're letting you know about it, get in touch with them, but we don't want to hear back from you. I would say that's probably what 80% of letters from the ICO look like at the moment. So at the moment, they're behaving quite sensibly. Having said all of that, as you've probably read already, over the last 10 years or so, we've seen more fines for marketing than anything else. But what I will just say for that is that those are spammers. So although it is the most commonly issued fine, these are people who aren't, they're not even trying, they're behaving appallingly. Often their marketing campaigns, they're really harassing people. And that's the ICO's angle, is you're not treating people fairly. You're not operating within the boundaries of the law. We'll take some action. So looking at a little bit more about the difference between a service-based communication and marketing, and excuse me, one moment, and what the differences are. So service-based communications, as I've said already, it must not have any promotional content in it whatsoever. And this also applies to surveys. So if you're sending a survey out after an event, or for whatever reason it may be, is you can send surveys out without the individual. You don't need consent for surveys. You can do it under legitimate interest, so long as in your privacy notice you've been clear that you may send surveys out, and the channel, as in email or text message or whatever, that you will use to send that survey out. But I say no promotional content in surveys. If you're going to put promotional content in the survey, you're going to need consent to do it. So things like delivery of a contract would be a good reason for a service-based communication. People can't opt out from service-based communications. So sending emails, as I say, pre-event to remind people what they need to do and have ready and bring with them. They can't, those should not have an unsubscribe on them. If people feel very strongly about it and say, I really, really don't want to receive these, then potentially you should honour their wishes, unless that service-based communication is mission critical, in which case it's a no, I'm really sorry, you have to, we have to send this to you. Also, anything to do with accounts and records, so where if somebody makes a if you have somebody who regularly, Sarah, you have a question.
Hello, sorry. It's actually Wendy's question that I want to ask as well. She's asked it in the chat though. Just whilst you're talking about service-based comms, she said if we send out a service-based comms via email, but we have a generic email footer that includes an upcoming event, does that make it marketing? I second that question, if that's okay.
I was wondering how far we get into this conversation today before somebody asked the email footer question. It's in the slides later on, but let's answer it now. The answer to the question is if you put an event in an email footer, that turns every single email the charity sends out into a fundraising email. Now, a lot of charities do it, and I can't remember. I was racking my brains when I was doing the slides as to who got busted for it, and it's a long time ago. I'm going to say it's 6 or 7 years ago. The ICO had a pop at a charity for doing this. They didn't get fined, they were just publicly told off for doing it. And I searched the ICO's database of enforcement action and I couldn't find it. So that's the answer to the question. But as I say, is a lot of people do it and the ICO haven't taken any enforcement action since, on the basis that the majority of emails that go out usually go out from a charity generally go to corporate entities. You're not on a day-to-day basis sending emails to private individuals, although as it does, sending emails to patients possibly and their families. The risk is much lower, but that's what the law says on it. It does indeed turn it into a marketing email. I'm trying to keep a bit of an eye on the chat, by the way, but it's quite hard to keep an eye on that and remember what I'm talking about. So I kind of hope that answers the question, but it's probably not the answer you were looking for. Sorry. As I've mentioned already, also with service-based communications, it's anything about, it's any operational instructions about an upcoming event or any operational instructions to a supporter or even to a fundraiser, a volunteer fundraiser. Those are all service-based communications. So in terms of marketing, well, the ICO's guidance says when it comes to sending marketing to people, and I quote, there should be no surprises. They should know what you're going to be sending them. So in that privacy notice, when they signed up to receive marketing or fundraising communications or both, you were clear about what they could expect to receive and the channel by which they were going to receive it. What you can't do is you can't bundle channels. So when somebody subscribes to marketing, you can't say, for example, tick this box if you want to receive, fundraising communications by email, post, and SMS. You have to split the channels out and be clear about it. And in the ICO's recent action against HelloFresh, which you may have seen, was that last week or the week before, they got fined, I think it was 140,000. The ICO did say that, they weren't being clear with people about the channels by which they were going to send the marketing and giving people a choice. So pre-GDPR, you were allowed to bundle, but since GDPR came along, you have to be explicit. I would say that even pre-GDPR, the Privacy and Electronic Communications Regulation did say that you had to be explicit in terms of the channel you were going to use. I would say that SMS marketing, and when I say marketing, I'm kind of talking about fundraising as well. So marketing equals fundraising. SMS marketing attracts a lot more complaints than any other channel. Don't really know why, but it does. People find it more intrusive and annoying. Having said that, bizarrely, people prefer service-based communications by text message. So, I mean, it makes no sense at all. So back to marketing and what the rules are. Well, so we must have, as I say, told people at the time we captured their information that we intend to send them marketing. I'll talk about soft opt-in in a minute, but then either capture their consent or giving them the opportunity to opt out. We need to then define what our legal basis is going to be, as I say. So it could be consent, could be legitimate interest. And if we're going to use the telephone for marketing or send stuff by post, we need to check if we need to run the addresses by the telephone or mail preference service or not, because there are some circumstances where, well, if you're relying on consent, you don't need to worry about the telephone preference service or the mail preference service. It's only when you're using soft opt-in. All communications have got to have an unsubscribe. And when I say that, that's all marketing communications. Although the ICO prefer consent, we don't always have to use consent. And well, as I say, I'm going to talk about that in great detail shortly. However, right now, if it's a fundraising communication, fundraising electronic communication, it has to be explicit consent. There's no way around it. Right now, you cannot use soft opt-in for fundraising, electronic fundraising communications, although the rules around the telephone are a little bit weird. I say that's don't know why the slides aren't jumping. I'm having to press the button manually. So the big thing everybody wants to know about the change in the law. So we should have had this. Had it not been for COVID, we would have had a new law by now, which was going to extend soft opt-in to fundraising. So all you would have had to have done is when you captured people's email addresses and phone numbers and things, said, we might send you fundraising communications, unless you'd rather not, tick here. And away we'd go, and you get a much better subscribe rate with soft opt-in, as you probably all know. However, I was chatting to somebody at the Information Commissioner's Office about this a month or so ago, saying, actually, less than a month ago, when we came back after Christmas, said, where are we with this? When's it going to happen? And the person at the ICO who's on the legal team said to me, it is extremely unlikely we're going to see this law within this Parliament now. This Parliament has more important things to deal with. It's slowly chugging its way through, but it's very, very unlikely that you're going to see this happen this year, which is a real shame, because there's so many great, not just in addition to allowing soft opt-in for fundraising, there's so many other great things within it. Obviously, there's the change in the cookie laws, which it means you don't have to, if you're only tracking people on your own website, and you're not using off-site tracking, where, for example, I come on your website, then I go on to, I don't know, the eBay or something like that, and I get your banner down the side. That will still need tracking cookies and consent, but on-site tracking, you will not need consent. Just whilst I've mentioned that, and it shouldn't apply to any of you here, but I will just mention it. There's a new piece of European legislation called the Digital Markets Act, which came in last year, but becomes fully enforceable in March. And in a nutshell, if you process the personal data of anybody of a European citizen, which is very unlikely, but that would include a European citizen visiting your website, then you must comply with the Digital Marketing Act, which has some even more onerous rules around tracking cookies. it imposes enormous fines on what they call the gatekeepers, which are people like Google, Facebook, all these digital content providers. And well, Google have really got their finger out on it and are providing a lot of tools. All I would suggest is that you go away and run a scan on your website and just check if you get any visitors from the EU. Yeah, and it's the odd one here and there, which might be just by accident, you can ignore. But if you are getting a steady trickle of EU people visiting your website, you need to comply with this law, because the fines make the GDPR fines look small, and the European Union, who will be the people fining you, and also you would have Google prosecuting you as well for not complying, will be down on you like a ton of bricks. It's the Digital Markets Act. I've actually written a white paper on it, so if you want my email address is at the beginning of the slides. When we get to actually, if you need my email address or my contact details, if you contact Hospice UK, they'll actually, I'll stick my email address in the chat. Hang on a minute. If you want the white paper, send me an email and I'll email it over to you. But it's worth checking out. Okay, moving on from that, let me just move the slides over. So, as I mentioned at the very, very beginning, the ICO's key grumble with data controllers in relation to marketing and fundraising when they're taking enforcement action is that people haven't been clear with the person signing up to your mailing list or to the subscriber. So it is absolutely critical that your supporter privacy notice, I would stick it in, I'll put it in all of your out-facing privacy notices, a clear statement on marketing, fundraising, also surveys if you send them. Even if you don't send surveys, I would still just put a line in there about, we may send surveys by email from time to time. Stick it in there, then at least then if you want to do it, you've got, you've told people you might, but be as transparent as you possibly can. Obviously, also explain to people in that privacy notice how they can unsubscribe if they want to. Also, where you are capturing people's consent to send them fundraising communications, as I've mentioned already, you have to give them that choice of channels. So on that subscribe form, tick boxes for what you want to do. With marketing though, and whether you'd want to have a separate marketing list and a separate fundraising list, a few charities do, but most don't, then you could use soft opt-in. Soft opt-in is perfectly acceptable. So the definition of soft opt-in is, I'll come to the question on there in a sec, is that at the time, for example, you capture the person's email address, you need to tell them that you're going to potentially send them marketing by email, and if they'd rather you didn't, tick this box to unsubscribe. So that's what soft opt-in has to look like to be compliant. Obviously, consent is the opposite of that, which is tick this box if you want to join the fundraising list. Oh, what's the question? So in terms of the question from Michelle, I assume we're talking about the privacy notice there. Should this also be set out on each comment? So yeah, each time you send, so if what you mean, Michelle, is every time you send a marketing or fundraising communication out, should there be like a mini privacy notice on it? The law doesn't require that. All the law requires is that there's an unsubscribe on it. It tells people how to unsubscribe. If you wanted to have a sentence that something like, you're receiving this because you subscribe to our fundraising mailing list, blah, 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 you can do that if you think it might help give people comfort and that they're not being spammed, because people do sometimes forget that they've joined marketing lists. I think what's critical is that if you haven't sent anything to somebody for a long time, so for example, and I would say a long time is sort of 6 months, people forget they subscribed and they get a bit grumpy with you sometimes. So I'm not suggesting you fire stuff at people every week, because firing stuff at people very frequently causes people to unsubscribe, but finding that happy balance in the middle, that people, just keeping people engaged with you and reminding them they're on the mailing list. As I say, don't bombard people with messages. The ICO think that's unfair. As part of their action against HelloFresh, they raised that people, the company was just sending too many emails and cheesing people off. Wealth screening is a bit of a funny one, and as you're probably, many of you are aware, about when was it? It was about 2018, I think, when the ICO fined 13 charities for wealth screening, amongst other things, as being inappropriate. In a nutshell, I'll give you an example. Many years ago, and it is many years, about 15 years ago, I sat in the fundraising department of a charity, and this charity, which deals with a particular sector, most of their supporters are from a particular community, and they were sat there reading, and this community has quite a few newspapers and magazines that are specific to them, and they were going through all these local magazines and bits and bobs, looking at what's going on in the community and looking for their supporters. And they go, oh look, there's so and so, they're a regular supporter. Oh look, their daughter has just married so and so, who's actually quite wealthy as well, because generally kind of rich people marry rich people. And they went into their Razor's Edge account and updated on Razor's Edge that this supporter's daughter, called so and so, has now just married so and so, whose father and mother are so and so, and they're building this enormous spider's web of information around the supporter, of who they know, who their business associates are, who they're married to, who their family are, who their extended family are, because especially with major donors, rich people marry rich people hang out with rich people, and hopefully you can get introductions, and this is why they do it. But of course, it's secret processing, because these people have no idea that you're holding all this information on them, let alone all the extra information you're holding on the actual supporter themselves, but on their associates and family and friends. You're now holding information on them too. Now, whether any of you are doing this, I have no idea, but this was the core. When the ICO took that action against those 13 charities, this was a big part of it, that there's all this secret processing going on. And that's before you get onto the wealth screening, which is when you've got your hopefully your next major donor, and you go off to do some digging around on them in the background. And there are companies out there that will do wealth screening searches. You need their consent to do it. People were doing this under legitimate interest, but it's very, very intrusive. And I had, at the time this was all going on, I was actually with another charity, and the chief executive was just on their way to go and see a potential major donor. And they said, oh, can we do some wealth screening on them? And I said, well, you're going to need their consent to do it. And they said, oh, sure, well, you do, right, create a consent form for us. So we did that, passed it to her, and she goes, I can't ask them to sign this. They'll go nuts if they see what we're going to do. And that's kind of the point. And what the point the ICO were making is, if you're not prepared to tell somebody to their face through a privacy notice what you're going to process because you're embarrassed by it, then you shouldn't be doing it. And I always think with data protection, if you ask yourself the question, if that was my personal data and the way I was being treated, how would I feel about it? And if you feel that you'd be a bit put out by it and felt it was privacy intrusive, then you probably shouldn't be doing it. Anyway, moving on. I think we might have covered what's on this slide. Yes, we have. So we can move on from that one. So, marketing or not marketing, or fundraising, that is the question. So, as I've mentioned already, surveys with no promotional content, not marketing. And there you go. Email footers promoting your annual challenge or event, that's fundraising, that is marketing. Thank you letters to supporters. So if somebody makes a pledge or a donation to you, sending them a thank you letter. Again, so long as there's no promotional content in it, so you're not saying, thank you for your donation, blah, 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 blah. This is how we're going to use it. We're really grateful. Oh, by the way, at the very, very end, you know, it would be great if you could take part in another event for us, or, you know, that suddenly turns it into a marketing email. But a nice vanilla thank you letter, service-based communication, you can send that out. So even if somebody just sends you a donation who you've never heard from before, they're not a known supporter, they're not subscribed to any of your marketing lists, you can write to them and say thank you. That's not a problem. As I've mentioned already, anything about arrangements for an event, not marketing. And this last one's an interesting one. So personal handwritten letters to potential major donors trying to arrange a meeting to discuss their potential support of the charity. Is that marketing? Well, yes, it is, but it's about the lowest risk marketing you could possibly do. True one-on-one, even emails, although it is strictly speaking marketing, a lot of charities do it, and I've never seen anybody get in trouble for it, because if it's well written, and it's, you know, you're not specifically asking for money, it's more about, can we sit down and talk about how you potentially, either individual or your business, could possibly support us, you'll get away with it. And that's just been recorded as well. So if somebody does that now and it all goes horribly wrong, I'm in a lot of trouble. Somebody just asked a question there for clarity. Thank you. Funds. So for clarity, if we send a thank you and say how we shall use the funds, but do not promote any other events or campaigns, can this be considered marketing? Because we are discussing no. So if you're telling them how you're going to spend their money, that's not marketing. That's just, yeah, thank you for, you know, thank you for your 50 quid. This is how we use the money. I think it's an important thing to let people know how you use the money. So that would not be marketing, Rachel. And then we've got Nikki here. If you send a thank you, can you ask them if they want? Okay, right. That's a good question. So you're in communication with somebody. So let's say you're sending them a thank you letter or email, and within that you invite, so they're not currently a subscriber, and you invite them to join a mailing list. That turns that email into marketing. Now, Flybe, although they've gone bankrupt now, the airline, and Mazda, the car manufacturer, both got very severely fined by the ICO for sending out a service-based communication. But at the very, very end of the service-based communication, it said, oh, by the way, if you want to join our mailing list to keep in touch, click here. And the ICO, and this went out to people who weren't on the Mazda or the Flybe mailing list. So it went out to thousands and thousands of people, and the ICO very severely fined them. So yeah, can't do that, folks. And do you need consent from a major donor when carrying out due diligence as to whether or not to accept a major donation from them? That's a really good question, is that? So do we need consent to do DD before we accept a major donation? Now, I guess that's from a money laundering and goodness knows what else point of view. Absolutely not. It's probably actually a statutory requirement placed upon you that if you've got any kind of concerns about a significant donation and the authenticity of it or the legality of it, then yeah, you must do that due diligence. I do wonder, actually, I've never ever been asked that before. In fact, I'm going to write that down. That's such a good question, Nick. I'm going to write that down. I would suggest that if that is something that pops up now and again, you need to put that in your privacy notice to let people know it's something we might do. So good one, Nick. Every day's a school day, even for the guy doing the training.
David,
I'll tell you what, Nick, after today you can have the weekend off. Okay, so distinguishing between different sorts of communication. So this, and I think this comes into a question somebody asked a moment ago, between what's the difference between a solicited and an unsolicited communication? And this is quite important especially when it comes to fundraising. So solicited communication is something that either the individual, so the supporter, has invited, so they might even have made an inquiry about something. So a potential supporter gets in touch and says, you know, thinking of, thinking it might be a legacy, thinking of leaving a legacy. Can you provide me with some information, please? So you can respond to that inquiry, because that's a solicited inquiry. It's actually potentially a fundraising communication. And you can go back to them and say, well, this is how it all works, and this is how this is what we'd need from you, and this is how, maybe you might say, this is how we'd spend the money, and so on and so forth. And you could even, in that initial response, as long as you were sensible about it, even talk about, although they're inquiring about a legacy, you could take that opportunity to say, there are also other ways in which you can support us as well, such as, so you can expand the scope. That goes out. Now, if you never hear from them again, if you chase them a second time, that becomes a marketing email. And if you haven't got consent to, because this is a conversation about fundraising, if you haven't got consent from them, then strictly speaking, you can't send that second email chasing them up saying, oh, are you still interested? Now, applying a little bit of common sense to this and working on the basis that the ICO are going to play a fair game with you, sending a second follow-up email if they go cold on you, just saying, oh, you made an inquiry, did you get our, we sent a response to you on so and so, hopefully answering your questions. Is there anything else you need from us? And it would really have to be that vanilla. Absolutely nothing of a promotional sense in it whatsoever. Keep it very, very ethical and vanilla. And on the 1,000,000 to 1 chance they complain to the ICO, the worst you would get is just told, look, we're a little unhappy about that. You wouldn't get busted for it, but keep it ethical, keep it to the point, and you'll be okay. Beyond that second follow-up, or should I say, beyond you've responded to the initial inquiry, you then followed it up a few weeks later because you've not heard from them with that very vanilla letter. Anything beyond that is asking for trouble. No, you don't need consent. If you hang on, with a major donor when carrying out due diligence, do you need consent? Sorry, boss, we just diverged for a second. Do you need consent from a major donor when carrying out DD as to whether or not to accept the major? So we've answered that one. I'm losing my grip. So if someone has made a donation, but we do not have any consent preferences for them, can we ask them in an email for their preferences? Right now, Jessica's question there. So again, asking them in an email from that person who's made that inquiry, would you be okay for us to add you to the mailing list, or even providing a link that says, if you want to join our mailing list, click here. That turns it into marketing. That's exactly what Flybe and Mazda did. So that will get you busted. The only way around that is in a telephone call. So if you've got somebody who looks interesting and you can negotiate a phone call with them, that gives you the opportunity to ask the question. And I appreciate asking a question face to face to add somebody to a marketing list is quite a tough question to ask. But it's also harder for somebody to say no verbally than putting a link in. But you can do it over the phone, but you cannot do it by email or any electronic means, unfortunately. So we've covered what solicited looks like. In terms of unsolicited, essentially, it's what would also be called cold marketing. So there's either no pre-existing relationship with this person whatsoever. So that could be where we are just out there looking for major donors, there's all sorts of databases out there with people who have funds where they give to charities, trusts and what have you. That would be a cold approach, but they're all legal. Those trust funds or whatever they may be are all legal entities. So you're allowed to approach them. That you're approaching the trust fund. You're actually not approaching the individual, bizarrely. But anything with a private individual, and then we're back to that private subscriber situation again. You're going to need consent to talk to them about anything to do with marketing. There's a slight exception on that, possibly with postal marketing. That will come on in a minute. And Rachel asked, what's this one here? Would it be okay to do a consent mailing postal to supporters whom we haven't recorded consent for a channel? So basically, I'm guessing there, Rachel, we're asking, could we physically write to people and ask that question? If they are, I'm going to leave that question there for a minute, because I'm going to come on to something in a minute that will potentially answer that question. For some reason, the slides aren't moving on. So, and this kind of comes onto it here. So in terms of legal basis, and this is critical to answering that question, Rachel, about what you need when sending fundraising and marketing to individuals is, if it's going by post, you don't need consent. However, there needs to be some sort of pre-existing relationship with them, and you need to comply with the mail preference service. So, for example, for whatever reason, you have my postal address, and it doesn't matter how you got it. In the privacy notice, we've said that we might send, fundraising and marketing by post. So you've told me you might do it, and you've also told me how I can opt out with it. You don't have to actually give me the option there and then to opt out with postal marketing. You have to run it by the mail preference service. That's all I will say is, so then in answer to Rachel's question is, so on the basis that there's some pre-existing relationship between us, you don't have my consent to send postal marketing to me, but I'm not on the mail preference service, so you can send me stuff. In that letter, can we also add in that letter something along the lines of, look, you know, postal marketing is really, really expensive. We'd rather spend donations on services than sending, stuff out by stuff to our supporters by post that costs, £1.50 a shot. It would be really helpful if you've got an email address or whatever it may be, is that we could subscribe you up electronically. That was a great way of doing it. Yes, you can do that. So hopefully that answers your question, Rachel. I had another meeting for doing. Okay, right, fair enough. Okay. Okay, fine. Right, just catching up on the chat there. So telephone cold calling is prohibited. I'll just say that right now. Even though, well, specifically for fundraising, cold calling is prohibited. For marketing, cold calling is allowed, but the ICO say that it breaches the first principle of data protection, which is the fairness principle. They don't feel that cold calling people is fair. So I'm sure you'd never do it, but if you were thinking about it, don't do it. So telephone marketing or telephone fundraising, if again, it's a bit like postal, so long as there's a pre-existing relationship with them, you've told them that you might call them to promote fundraising to them, they haven't objected to it, and they're not on the telephone preference service, then you can call people up and fundraise to them. The only thing you can't do is you can't leave them a voicemail, because bizarrely, if you leave somebody a voicemail, that then becomes electronic mail for which you need consent for fundraising. So don't leave voice messages. However, having said all of that, if people have consented to receive marketing telephone calls, so you're working with consent rather than legitimate interest, which is what I was just discussing a moment ago. So we're using consent. You don't need to check it against the telephone preference service. You can just go for it, and you can leave a voicemail as well. With making calls to businesses, so if you're trying to get corporate subscribers, then you have to the rules are a bit softer, that you don't need consent at all, and if they're not on the business telephone preference service, you can call away. But if they are on the business telephone preference service, you cannot call them, full stop, end of. But the rule, generally speaking, well, the ICO have never, I wouldn't say no, it's not true. For the first time ever, A couple of months ago, the ICO busted somebody for making cold calls to corporations that were on the business telephone preference service, but they only got busted because they were harassing people, they were being rude to people. They were, quite frankly, the fact that they were making cold calls was the lesser part of it all. But it's things that you would never do. Email and text message. At the moment, if it's fundraising, it has to be consent, and that's the end of it. There's no more to say about that. Now, the reason the ICO prefer consent, because if you look at all of the ICO documentation, although they talk about soft opt-in, which, because remember, we can't use for electronic marketing for fundraising, but you can for postal and telephone, is they feel it empowers the individual, it gives them more choice, it means people know what they're going to get. My clients who are big marketing agencies, we've had conversations about the difference between soft opt-in and soft opt-in and consent for years. And the bottom line is that if you go down the consent route, you get a much higher open rate than you do if you go down soft opt-in. If you go down soft opt-in, a lot of companies will get an open rate of, single figures. In fact, if they get an open rate of 10%, they feel they're doing really well. Whereas if you go down the consent route, if you're getting an open rate of you should see something 20-30%, and sometimes people get nearly 50% open rate, which is staggeringly good. And although your subscriber base is much smaller, when you actually look at the statistics, it's more efficient because the subscriber base might be smaller, but overall the open rate is higher. So you've got more people looking at what you're sending out. And also you're not wasting money sending stuff out to people who aren't opening it, because even sending stuff electronically does cost money. Quick question here. We're currently looking at sending a mailing out to people that we have opted in on legitimate interest. When you say you've opted in on legitimate interest, so what you mean is you've told them in your privacy statement you're using legitimate interest, not consent. Thanking them for their donation last year, and if they can make another contribution again, will be worded much nicer. We'll be sending this communication via post. That's the critical thing. On being with people, that's fine. That's absolutely fine. Is that no problem doing that? Thank you, Kelly. Good question. And then we've got George here. If attaching a keep in touch statement to marketing material, does this need to be linked with your data processing statement? If attaching keep in touch statement to marketing material, George, can you switch your microphone on, Georgia? And I'm not 100% what you mean by that. Could you verbalize it, please? If you're not too shy.
Hiya. Sorry, it was I was discussing it with a colleague, so it's come from her.
Hi, on all our marketing material, we have your data statement, the legal basis for processing your information, etc. And we also have a keep in touch statement, which is the consent and preferences requests. Our marketing team are inquiring if we use the keep in touch statement on any material, do we also have to attach the your data statement as well?
So are these people already subscribed to, is this going up by post or by email or possibly both?
It's on like event leaflets primarily.
So it's a paper form.
Yeah.
Right. Okay, cool. Right. So you don't need, all you need is, well, if the keeping in touch bit at the bottom of the form says, if you'd like, as long as it says something like, if you'd like us to keep in touch with you about, future events and whatever, and how you can support the charity, tick here, or put your email address in this box.
Yeah.
Then that's all you need to say. You don't need to you don't need a big privacy statement, as long as you're being clear to people about what it is they're signing up to.
Yeah, what they're consenting to. Yeah.
Thanks, Georgia.
Thank you.
Fabulous, thank you.
And then we've got Bina here. How long can we email supporters who have opted into emails but haven't made a charge? I'll answer Bina's email there now, which I was going to talk about this later, but I think we're getting short on time here. I'm happy to keep on going, by the way, everybody, until we've done all of this. So I'll just keep on going. And at the end as well, if people want to ask questions at the end, I'm in no rush to go away. I'll stay for as long as people have got questions and want to talk about stuff. So this is a really, really good question, and this almost comes back to the ICO's prosecution again of HelloFresh. So what I would call gonaways. So people who essentially haven't sent anything, haven't supported you for absolutely, for a number of years. At what point do you call it a day? And I'm just going to actually move my slides on here to something quite, come on, where are we? Yeah, marketing to gonaways. So about, I don't know, when was it? A couple of years ago? Well, July 22, that's when it was. So the ICO, if you were subscribed to the ICO's newsletter, which I am, they sent this out. I'll let you read that for a second. Okay, so bearing in mind the ICO were using consent to subscribe to their newsletter, because with consent kind of doesn't last forever, and you have to re-permission it now and again. So that was the first. So there was that statement, and then there was this was the next page you got. So it's a bit fuzzy, is that, isn't it? Is essentially you then had to re-opt back in to stay on the mailing list. And they did this, and I thought to myself, here we go. They're about, because the one thing the ICO are very, very good at is not being particularly compliant themselves, and then thinking to themselves, we need to get our own house in order first, and then we're going to start prosecuting people. So I thought to myself, we're now going to see the ICO taking enforcement action against organisations where, as you just described, Bina, people have essentially sort of become a bit of a gone away, or they've been on a mailing list for a while and we've not really had any interaction with them, and do we need to re-permission them to opt them almost back into the database? And the ICO were basically saying we need to do this. And if you read the ICO's marketing code of practice, they do talk about where that you should be periodically refreshing your mailing list. Now, other clients' experiences of doing this have not been good. If you went out and re-permissioned your fundraising, your supporter mailing list, let's say you've got 100,000 subscribers on it now, and you emailed all 100,000 people, that list would turn from 100,000 to 10,000. You would lose the vast majority. It's likely you would lose the vast majority of your subscribers. It would be catastrophic, which is why people are not keen on doing it. Some big organizations do it every year. A much better way of doing this, because we do need to consider with the ICO's prosecution of HelloFresh, where another one of the ICO's beefs with them were that with people who had stopped buying from HelloFresh were continuing to receive marketing from them for up to 2 years before eventually they just automatically unsubscribed them after 2 years. And the ICO's issue with that was, number one, they felt that 2 years was too long, and number two, that they hadn't been clear with the customer that they were going to do this. So the ICO, and this is the first time the ICO have taken action for this very specific point on gonaways. So our take home from this, and in answer to Bina's question, is that yes, we need to be monitoring what I would call engagement. So I wouldn't be necessarily re-permissioning my database as the ICO did here back in July 2022. I would be monitoring, and it's easy to do it with electronic marketing. I would be monitoring basically open rate. And if you've had somebody who hasn't opened an email in, say if you're sending something out once a month and they haven't opened a single email in a year, I think you need to be asking yourself the question, is this person really engaged with us or not? And should we be unsubscribing them? Or actually, should we send them an email out first saying, look, do you still want to stay on our database? If you do, get back in touch or click on this link, and then that would reset the clock. But if you don't hear back from them, you should consider unsubscribing them. You also need to make sure in your privacy notice, because going back to the ICO's prosecution of HelloFresh, that we're clear with people that if you disengage with us, when that's because you stop supporting, we don't receive a donation from you, or whether it's because you stop, or you stop opening emails from us, then after a period of time, you will be automatically unsubscribed. Now, what that period of time looks like is a tough one, and I would generally say you're looking at about a year, 18 months max. If you want to come up with your own number, then the way to do it is to essentially, you have to do some number crunching on Razor's Edge or whatever system you're using, and look at the period of time that somebody kind of stops engaging with you. If they are going to come back as a supporter and with a donation, what's in 80% of cases, what's that period of time? So if in 80% of cases they'll be back within a year, then that's kind of your answer to your question. Is they're not back within 13, 14 months, then we're going to unsubscribe them. So just a question from Rachel here. If I understand correctly, we are saying for lapsed supporters, we are advised to not contact those who have not responded for longer than 2 years. Does this mean we should not contact, it jumped up a bit. Should not contact lapsed and deeply lapsed, by which I mean 5 years, crikey, that is deeply lapsed. Are we considering the date of the last donation or the date of the consent captured? Is this only email or all channels? Okay, so it's that I would say somebody becomes lapsed at the point that you've lost touch with them. So whether that's because it's the last time they made a donation, or if you're looking at opens, the last time they opened an email. So they might not have donated for 5 years, but actually they're still opening something, might not open every email we sent them, but they open 1 in 3. I would consider that person still engaged with us, and I would leave them on the mailing list. But if we're not monitoring open rate and the only thing we can monitor is donation, then yeah, Rachel, I would say that looking at HelloFresh, 2 years down the line, no contact from this person whatsoever, you're really pushing it. 5 years is no way, Jose. I'm data protection officer, and I'm not telling any secrets out of school here. I'm data protection officer for Refuge, the women's refuge charity, and we take the view now that if for us somebody becomes a gone away at 18 months, and we'll leave them on the supporter database actually for 5 years, and after 5 years, then unless there's some financial information that we need to retain for obviously 7 years, at 5 years we expunge them from the fundraising database if we've had nothing from them and there's no engagement. But we monitor email open rate, so as long as they're opening emails, we'll stay engaged with them. And the final bit to Rachel's question, is this only email or for all channels? Obviously you can't monitor postal open rate, but it more importantly applies to electronic marketing, because that's where you're more likely to get busted. But I would say, putting my financial hat on, is if after a couple of years we've had nothing from somebody and we're regularly postal marketing to them and it costs a lot of money, I would be asking myself the question, am I getting any return on this? And it's almost a financial decision. But from a fairness point of view, if that person did complain to the ICO, and I can't remember what her name was, the little old dear in the PDSA, who got very severely busted by the ICO, if that person's gone a little bit dippy and the family get involved and there's a big pile of letters from you sat on the side, the ICO are going to say, why were you doing this? What's your lawful basis? This person's not given to you in donkey's years. You should stop doing it. And a lot of people won't unsubscribe from postal mailing, because actually unsubscribing from postal mailing takes effort. You've either got to pick the phone up or to the charity and say stop it, or you've got to, you know, if this is a more mature person who doesn't have an email address, they have to physically write to you, which they're not about to do. So you need to take some ownership for it. And this is the ICO's big point, is you've got to treat people fairly. It's back to where I started this conversation this morning, is if you can show you're treating people fairly and it goes wrong, the ICO will not get uptight with you. And we've talked about, actually, just going back slides a bit here, we've talked about managing consent, and that's what I was just talking about there in terms of slides, and soft opt-in and just keeping it fair. And as I've mentioned already, soft opt-in only applies to marketing and not to fundraising. I appreciate we're like pretty much out of time, so I just want to mention a couple of things quite critically. The other thing, in terms of people's legal rights given to them under data protection legislation, it's important to remember that one of their absolute undisputed legal rights is the right to object to marketing and fundraising. So any unsubscribe needs to be promptly dealt with needs to be actioned within 21 days. And the ICO get really, really uptight about failed unsubscribes, and you'll not get busted the first time, you probably won't get busted the second time it happens, but if they see a steady trickle of, you know, only one or two people, you know, complaining about inefficient unsubscribing, you will find yourself in trouble. But it's important that also that across the charity that people understand what an unsubscribe looks like, because, you know, again, I know at Refuge, and I've actually had one this morning at Refuge come into the DPO inbox, which is a real old rant, and I had to read it twice to actually get my head around what it was they were asking me to do. And actually what they wanted me to do was just unsubscribe them, but it wasn't clear. And I have emailed them back and said, I'm just being absolutely clear before I do this, what you want me to do is this. So thankfully that came to me, but had that just gone to our general info app and gone to the help desk, I doubt that they would have really understood what that person wanted, and it would have probably disappeared into the ether. We've talked about data enrichment, which is basically the wealth screening and enriching your Razor's Edge database and the legalities of that, which are really isn't, unless you've got somebody's consent to do it. Having said that, the law does say on the other hand that if you've got somebody's personal data, you might, you know, you should be keeping it up to date, but it's not quite as black and white as that. And the ICO, when it comes to fundraising, have a very specific point of view on this. So this is quite important. So if I subscribed to your fundraising list, and let's say you've got my name, my postal address, and maybe my email address, but you haven't got my telephone number. There are companies out there that you can run this data through to have it enriched to find out what my phone number is, and also to see if my email address has changed. You cannot do that. And the ICO are really, really firm on this when it comes to specifically fundraising, because they take the view that although on one hand the law says you should keep people's data up to date and do things in the most, you know, proper fashion, is when I supplied you with my postal address and my email address so you can contact me about supporting you, that's how I wanted you to do it. I didn't want you to go off, find out what my phone number is, and obviously if I'm not on the telephone preference service, then start ringing me as well. That breaks the law. So please don't do that. That will get you in a ton of trouble. Talked about gonaways, talked about that, and that's it, folks. Crikey. So we kind of went back